children couldn't even speak. Yeah, so, I mean, we're talking, this is very, it was terrible. I mean, it looked like almost feral animals. It was terrible. So when we're talking reading and writing and education, we're talking a whole nother level of expectations here.
On the day 16 children were rescued from a home in rural Ohio, their own uncle went on Facebook and wrote 5 words: "The state knows something." He posted it on June 30th, 2026. The same morning, sheriff's deputies executed a search warrant at a house on Ohmer Road in the Village of Hamden. 20 people were inside. 16 were children, ages 17 months to 18 years. The 4 adults in the home are now in custody, each charged with 16 felony counts of endangering children. All 4 have pleaded not guilty. The uncle's name is Jeremy Russell. His sister, Elizabeth Siders, is the children's mother. She was 15 when she married their father in West Virginia in 2008. 17 years of continuous pregnancies followed. And according to Jeremy Russell, someone in Ohio's welfare system was told about this family. Told, in his words, to the maximum. Told, he says, before June 30th. You are inside quiet record. Tonight, we are not walking you through what officers saw in that house. We are asking a harder question. What does the state's own record actually show? And does one Facebook post from a family member expose a question the official story hasn't answered? The rescue happened at approximately 10 in the morning on Tuesday, June 30th, 2026. The location was a home on Ohmer Road in the Village of Hamden in Vinton County, Ohio. Property records list the house at 1,336 square feet, 5 rooms above ground, 1 bathroom, a basement of 518 more square feet. 20 people were living inside it. 16 of them were children. The Vinton County Sheriff's Office was not there for the children. They had a court-authorized search warrant tied to a separate investigation, one that Sheriff Ryan Kane has not publicly described. The warrant documents are sealed. When deputies and agents from the Ohio Bureau of Criminal Investigation entered, they found 16 children who no local system had a record of. 7 were transported to Columbus area hospitals that same day. At least 2 were care flighted. 1 was in intensive care. All 16 were placed in the temporary custody of the Ohio Department of Children and Youth. By Wednesday, July 1st, 4 adults from the home had been arraigned at Vinton County Common Pleas Court. Gary Siders Sr., 73. Christina Siders, 67. Gary Siders Jr., 36. Elizabeth Siders, 33.
Afternoon.
Prosecutor William Archer described them
At
as the
10:30 today, the 4 defendants were arraigned on 16 counts.
Each was charged with 16 counts of endangering
second-degree felony, child endangering. They were
all 4 pleaded not guilty.
assessed a $300,000 cash or surety bond per defendant. They were ordered to have no contact with each other as co-defendants. They were ordered to have no contact with the victims. We believe, will be requesting court-appointed counsel and will anticipate getting ready for the next stage, which at this point would be a preliminary hearing if they request that, or if they don't waive it, and that'll be with their counsel. Right now, the abuse, neglect, dependency complaints that have been filed are being heard by the Vinton County Juvenile and Probate Court. The initial hearing occurring now, we are asking for temporary custody to Job and Family Services. The children are safe. They have been placed. We have some other issues we're still dealing with for their safety, but they are currently in a good situation and are being protected. The last thing I want to mention very quickly, particularly for our local community folks, is this is an intra-family situation. This is not human trafficking. There is nothing to put our other children at risk. This is clearly involved a multi-generational family in a very limited situation. We know the early reports came out that some of this might be going on, but we want to assure the public that their children in Vinton County are safe and they do not have to worry about these defendants.
What isn't on the public record, what the sealed search warrant is hiding, what Jeremy Russell says the state already knew, and what the defense attorneys are now telling reporters, is where this case actually turns. Ohio Attorney General Andy Wilson stood at a press conference on July 1st and used a word about the children that has traveled further than any other detail in this case. He said they looked, quote, almost feral. He said some of them couldn't speak. He said the 18-year-old couldn't spell her own name. He said none of them had been enrolled in school. 2 days later, one of the children's uncles, Joey Russell, another brother of Elizabeth Siders, went on Facebook and posted screen captures. Messages, he said, between his older nieces and an ex-boyfriend of one of them. Text conversations. Everyday phrasing. Correct spelling. "I thought my nieces couldn't read or write," Joey Russell wrote. These are messages between her and her ex-boyfriend. He says they had to break up because of her neighbor Mike. Clearly the neighbors knew. Clearly she could read, write, and speak. We just want the damn truth. How the teenage girls in the household had access to phones, tablets, or laptops has not been publicly explained. But if what Joey Russell posted is authentic, and Angenette Levy, the Law and Crime Network host who reported it, has been trying to verify, then the state's characterization of the children as illiterate and non-communicative is at minimum incomplete. That is one crack in the official narrative. The bigger one is Jeremy Russell. On June 30th, the same day the search warrant was executed, Jeremy Russell posted about his sister on Facebook. He described her marriage, at 15, to Gary Siders Jr., who was 18 at the time. Court records from Mason County, West Virginia, confirm they were married there on March 31, 2008. Ohio's marriage laws would not have permitted it. West Virginia's at the time did. Then Jeremy wrote something the state has not yet addressed publicly. Everyone knew about it. I told everyone, welfare supporters to the maximum. So state knows something. I don't get it. If Jeremy Russell is telling the truth, if he did contact Ohio's welfare system about his sister, about the children, about what he believed was happening, then the timeline of what the state knew and when it knew it is not what Andy Wilson has been publicly presenting. And the question of why no action was taken until an unrelated search warrant accidentally opened the door becomes the central question of this case. Before we go deeper, one thing. The 16 children in this story are alive. They are in state custody. Their names, images, and specific conditions are legally protected, and this channel will not push against that. But the question of whether Ohio's child welfare system was warned about them by their own uncle, on the record, in writing, is now a public question. If that question fades from public attention in the next 2 weeks, the way most true crime headlines do, the state gets to answer it quietly, or not at all. Andy Wilson has said Ohio will conduct a systemic review. Whether that review produces anything real depends on whether reporters, advocates, and the public keep asking the specific question Jeremy Russell has forced open. Not the shocking parts, the paperwork parts, the parts about which agency was contacted, when, and by whom. Subscribing to this channel is a 1-second action. What it does is tell YouTube that this kind of coverage, the kind that follows a story past the shocking week and into the accountability months, is worth surfacing. If you would want strangers doing that for children in your county, do it for these. Hit subscribe. Then stay with me, because what happens next is where the defense attorneys, the family members, and the state start telling very different stories. The most important on-record voice this week, other than the Attorney General, is a man named Dorian Baum. Baum is the court-appointed attorney representing Gary Siders Sr., the 73-year-old grandfather. On July 3rd, 4 days after the rescue, he sat down with Law and Crime Network host Angenette Levy for what became the first extended defense interview in the case. His pushback was direct. He said Attorney General Wilson's public characterizations were, in his words, beyond disingenuous. He noted that the original criminal complaint filed against the 4 Siders adults contained 17 charges. It was amended a day later to 16. That means the state, at the arrest stage, could not consistently document what they were charging on. Baum was clear this happens in preliminary proceedings, but he was equally clear that when the state has to take these charges to a grand jury for indictment, the number and severity of charges can change again. He said this: the state has provided what he called a modicum of the evidence to defense counsel. Discovery has been filed. The state has responded minimally. Everything Baum has seen so far is marked counsel only, which means he cannot publicly disclose it. But he told Levy directly that the characterization of the home he has seen does not match what Wilson and Sheriff Kane have been telling reporters. His argument, condensed, the state is criminalizing poverty. that an unkempt house is not a felony, that 2 grandparents and 2 parents living with 16 children in 1,500 square feet is unusual, but unusual is not the same as criminal to the second degree. He also raised a specific concern about his client's ability to stand trial at all. Gary Siders Sr. appeared at his arraignment in a wheelchair. He appeared to have difficulty hearing. He appeared to have difficulty understanding the judge.
How do you plead? Yes, I will enter a not guilty plea for you at this time then, and you can confer with counsel. Okay? Mr. Siders, would you like me to enter a not guilty plea for you as well? Until you have the chance to speak with an attorney? I will do that.
So let's
Baum has not yet been able to meet with him. The 4th of July holiday weekend closed the Southeastern Ohio Regional Jail to attorney visits, but his first task, when he does, will be a competency evaluation. In Ohio, as in every state, a defendant who is not competent cannot be prosecuted. None of what Baum said proves the state is wrong, but it establishes something the earlier coverage of this case did not. There is a live legal contest here, argued by named counsel, on the record, and the defense's account of what happened inside that house differs materially from the Attorney General's. That is the shape of the case now. 2 narratives, 1 state, 1 family, both public, neither yet proven. The mechanism by which 16 children could remain outside every official system for 4 years, the paper trail question, is still the harder story. Court records show that Elizabeth Siders was pregnant nearly every year between 2008 and 2025. She had documented children in 2008, 2009, 2011, 2012, 2013, 2014, 2016, 2017, 2019, and 2020. Then twins in 2022, again in 2024, and again in 2025. Angenette Levy has said publicly she is still trying to confirm whether additional children were stillborn during that period. That is 17 years of continuous pregnancies. Some of them in Vinton County, others, according to Wilson, across Gallia County, Pike County, Jackson County, and possibly Wisconsin. The family had ties to Mason County, West Virginia, going back to at least 2005. The Vinton County Local School District, the only district serving that geographic area, has publicly confirmed it has no records that any of the 16 children were ever enrolled. Ohio Revised Code Section 2151.421 requires certain professionals, teachers, doctors, nurses, dentists, child care workers, social workers, and law enforcement officers to report suspected abuse or neglect to their county's Public Children's Services Agency. Failure to report is a 4th-degree misdemeanor. The statute assumes children will encounter mandatory reporters at some point. If a family successfully arranges for children never to appear in front of a mandatory reporter, no pediatric visits, no school enrollment, no emergency room admissions, the statute has no fallback mechanism. There is no cross-check between the Department of Children and Youth and county property records. There is no proactive audit of homes with children living in them whose children are enrolled in nothing, which is where Jeremy Russell's Facebook post starts to matter. Jeremy Russell is not claiming a mandatory reporter met the children. He is claiming that he, a family member, on his own, without any professional obligation to do so, reported what he believed was happening to what he called welfare supporters, multiple times, over a period of years. If that were the only claim on the record, it might be dismissed as one family member's grief-driven guessing. But it is not the only claim. On the July 6th broadcast of Crime Fix, Law and Crime Network host Angenette Levy reported something else. Something she said she was told directly by a source close to the case, that Ohio's Job and Family Services Agency in one specific Ohio county may have previously visited the Siders family, and that after that visit, the family moved, in part, according to what Levy was told, to keep the children from being taken away. If that reporting is accurate, then there is a paper trail somewhere inside Ohio's welfare system. A trail that predated June 30th by years. A trail that either was not shared across county lines when the family moved, or that was, and no one acted on it. That is what the state has not yet publicly addressed, and it is what the pending review will either resolve or refuse to. Ohio is not the first state to face this specific question in recent months, and the Siders case is not the first Ohio case to raise it. In Franklin County, which contains Columbus, the extended family of an 8-year-old boy has filed suit against Franklin County Children's Services and one of its contracted caseworkers. The lawsuit alleges the caseworker assigned to monitor the family failed to adequately investigate abuse allegations, and that failure contributed to the child's injuries. That case is active. At the national level, in April of this year, the New Mexico Department of Justice released a report on that state's Children, Youth, and Families Department. New Mexico's Attorney General, Raul Torres, pointed to the deaths of 14 children over 2 years, all tied, his office said, to lapses in decision-making at the state agency level. Ask yourself something. If a family in your own county picked up and moved 3 times in 12 years, crossing county lines with children in tow, would your state's welfare database catch them the 3rd time they surfaced? The honest answer, in most states, is no. That is not a fringe concern. That is the mechanism these cases have used to stay ahead of the systems designed to find them. And every time it works because rural children's services offices are exactly the offices least equipped to keep up. These are not isolated incidents. They are pattern failures that occur when child welfare systems are under-resourced and reactive rather than proactive. According to state and federal workforce data, caseworker turnover in Ohio's rural counties ranges from 20% to 40%. Recruitment in rural areas is a documented, ongoing problem. The question Jeremy Russell's Facebook post forces is whether that broader systemic failure was also active in the Siders case. Whether a report was made, filed somewhere, and then lost in a rural children's services office where a caseworker had already left. Whether the family's constant moving between counties defeated Ohio's uniform statewide automated child welfare information system, the database that is supposed to share flagged cases across county lines. None of that will be known until either the state acknowledges prior contact with the family, or the search warrant is unsealed and shows what triggered the original parallel investigation. Both may take months. What can be said now is that the Franklin County lawsuit, the New Mexico report, and Jeremy Russell's Facebook post are 3 data points that all suggest the same thing. American child welfare systems are structurally reactive. They can respond well when a report reaches them intact. What they cannot yet do, in most states, is proactively verify that children in known households are being seen by the professionals the law expects them to be seen by. There is a case that everyone covering the Siders story is being asked to compare it to, and that comparison is worth handling carefully. In January of 2018, in Paris, California, 13 siblings ranging in age from 2 to 29 were rescued from a home where they had been held in conditions of severe abuse. The case is publicly known as the Turpin case. David and Louise Turpin were convicted the following year and sentenced to life in prison with the possibility of parole after 25 years. The parallel to the Siders case is obvious. A large family, prolonged concealment, a community that did not know, prosecutorial and public shock, national coverage that lasted about a week. What made the Turpin case different from most large family abuse cases is what happened afterward. Riverside County, California, undertook a review of its child welfare processes. The attorneys who eventually represented the Turpin children publicly said that the case spurred critical improvements to the county's child welfare system. Here is the part that matters for the Siders case. The Turpin family had never been reported to California's child welfare system either, not once, in the years leading up to the rescue. 60-plus mandatory reporters had not filed a single report on that family, because none of them had ever met the children. Sound familiar? The mechanism that produced the Turpin case is the same mechanism that produced this one. And it is the same mechanism that is producing the next one, right now, in a county neither of us has ever visited. In a 2021 interview with ABC News, Jennifer Turpin, one of the older siblings, said she wanted the Turpin name to be associated with strength rather than victimization. She has since published a memoir about her recovery. The Turpin case became an inflection point because reporters, advocates, and elected officials kept the systemic question alive after the sensational coverage moved on. That is the mechanism by which cases like this produce policy change instead of just producing views. The Siders case is not yet at that inflection point. It may not reach it, Whether it does depends almost entirely on whether the specific question Jeremy Russell has raised, whether the state was warned, gets pursued past the current news cycle. If it does, the review Wilson has promised will be forced to produce specific answers about specific agencies and specific decisions. If it does not, the review will produce a report that sits on a shelf. Which of those outcomes occurs is not decided by any single voice. It is decided by whether public attention holds when there is nothing new to shock people with. Which brings us back to the sentence, "The state knows something," written on a Facebook page by a man whose sister is now facing 16 felony counts. Written the day the rescue happened. Written without prompting from any reporter or investigator. What that sentence actually claims, read carefully, is limited. Jeremy Russell has not said which agency. He has not said which county. He has not said what year. He has not said which specific staff member received his report. He has not provided documentation. Reporters have reached out to him and, as of the most recent broadcast, have not received a substantive response. But what the sentence claims is enough to matter, because if any part of it is true, if Ohio's welfare system has any prior record of the Siders family in any county at any point in the last 17 years, then the state's current framing of the case is missing a piece the public deserves to know. Andy Wilson said in his press conference that the family was pretty good at hiding these kids. That framing places the failure on the family's ability to hide. Jeremy Russell's Facebook post argues something different, that the failure was also, at least in part, in the state's ability to act on what it was told. Both can be true, but only one is currently the official story. And the sealed search warrant, the pending discovery in the criminal case, and whatever internal records the Department of Children and Youth is now reviewing, will determine which framing survives the next 6 months. That is the specific unresolved thread in this case. Not the sensational parts, the paperwork parts, the parts about what a rural children's services office in southern Ohio actually did or did not do in the years before June 30th, with information that may or may not have been in front of them. Here is where the case stands, as of this recording. What is verified fact? 16 children were removed from a home at Ohmer Road in the Village of Hamden, Ohio, on the morning of June 30th, 2026. 4 adults from that home, Gary Siders Sr., Christina Siders, Gary Siders Jr., and Elizabeth Siders, have each been charged with 16 counts of endangering children. All 4 have pleaded not guilty. All 4 remain in custody at the Southeastern Ohio Regional Jail on $300,000 bond. Gary Siders Jr. faces 4 additional misdemeanor public indecency charges from May of this year. Elizabeth Siders and Gary Siders Jr. were married in Mason County, West Virginia, on March 31, 2008, when she was 15 and he was 18. Court records document 17 years of continuous pregnancies. Ohio Attorney General Andy Wilson has publicly committed to a systemic review. What is theory? What the sealed search warrant will show when unsealed. Whether Jeremy Russell's claim that the state was warned will be corroborated by internal records. Whether the state's characterization of the children's condition will hold up under defense scrutiny. What is invention? Any specific detail about the children's names, images, current medical status, or long-term futures that you may see circulating elsewhere. That information is legally protected. Any channel publishing it is speculating or fabricating. The 4 Siders adults are entitled to the presumption of innocence under both the state and federal constitutions. Their attorneys, Dorian Baum for Siders Sr., Thomas Stawley for Elizabeth Siders, and public defenders for the other 2, have made clear they intend to test the state's evidence at every stage. If you suspect a child in your own community is being neglected or abused, the Ohio Child Abuse Hotline is 1-855-642-4453. You do not have to be a mandatory reporter. You do not have to prove abuse. You only have to have reasonable cause to suspect it. The state is required to figure out the rest. One last thing before you go. 5 months from today, Ohio's promised systemic review will either have produced something specific, a policy change, a cross-agency audit, a new mandatory reporting protocol, or it will have produced a report that sits on a shelf and a headline nobody remembers. Which of those happens is not decided by Andy Wilson. It is not decided by Sheriff Kane. It is decided by whether the specific question Jeremy Russell raised on Facebook, whether the state was warned, is still being asked 5 months from now. If it is, the review has to answer it, publicly, on the record, with paperwork attached. If it isn't, the review answers to no one. That is where you come in. Subscribing to this channel is how you tell YouTube, and how you tell me, that you want this case followed past the shock week, past the arraignment week, past the news cycle, into the quiet months where a rural children's services office in southern Ohio either did or did not have a file open on the Siders family before June 30th. If Jeremy Russell was telling the truth, the state owes those 16 children, and every family who ever moved out of a jurisdiction to keep the paper trail from catching up to them, an answer. If he was wrong, the state still owes the same review, because 16 children stayed invisible for 4 years. And the mechanism that made that possible is still in place in every rural county in America until it is deliberately fixed. Subscribe if you want to be here when the answer comes. Then stay with us. When something moves in this case, you will hear it here first.